Okay, Jess, we did it. I, as promised, have brought my wine because wow, is it necessary after this week? So today is day 4. It's Thursday, October 15th, the last day of the Amy Coney Barrett confirmation hearings. Today was just outside witnesses. I did bring my wine. Thank you to Jackie Schwartz-Craig for surprising me with a bottle of wine today. It was very needed. So yes, today was just outside witnesses. And so the Democrats called people against Amy Coney Barrett and the Republicans called people for Amy Coney Barrett. But before we get into the, hi Jess, let's say hi to you. Get your voice in here.
Hi, I'm Jess Braverman and I'm the legal director at Gender Justice. And I have absolutely had it. I don't drink. So for all you non-drinkers out there, we're just going to feel the feelings.
Well, you can feel the feelings and drink water.
You can have the feelings really amplified with the wine. The feelings are what? Anxiety?
No, I'm not even that. I'm like downtrodden. I'm like I'm resigned.
Oh, that's a good one. Yep.
How about you? What are your feelings?
I feel like, I'm not the best at identifying how I feel. Like I am definitely like the one I know is anxious. So like it encompasses a wide variety of things. So I'm gonna say like super anxious. But yeah, so I think at some point in the day, like we've been watching this for 4 days straight, it's really hard to watch. And I think today I just had to kind of turn it off, but we're definitely still gonna talk about it though.
Yeah, and I did watch some of the testimonies. I don't think I could listen again to like another day where it's like calling to the moment of like the demise of democracy and the ramming this through and how unnormal this is. And to Christy Wesson's point yesterday, like how somebody who holds himself up as like a Christian moral person could let like literally the worst person in the world nominate them and just be comfortable. Like I think that I was just like, I can't. I just couldn't. So if you can't either, join us for canting today. But feel free to drop questions into the chat if you have
We're gonna like, we've got on the agenda like Dred Scott and Plessy we've mentioned them, but we haven't really talked about them. And so like, if you think you can't now, just wait till we talk about these like originalist gems.
Yeah, pull up your wine. It'll be great. I love what we're setting people up for. It's like, it's terrible. Grab a drink.
Turn it off.
Feel your
Why are you still watching?
Yeah, tell us how you're feeling in the comments. Okay, so we started out today with actually, like, I think this is important to note. So in order for Amy Coney Barrett to actually be confirmed to the Supreme Court, there has to be a vote out of committee, and then it goes to a vote with the full Senate. And there was a motion to schedule the committee vote for her nomination next week. And the ability to do that, they require 2 members of the minority. So 2 Democrats needed to be present in order for them to conduct business. And there was only one. Dick Durbin, who is one of the leaders on the Democratic Party in the Senate, noted that it was like the official, for the record, that he was the only member of the minority there. So technically, per their own rules, they couldn't conduct business. And Lindsey Graham was like, you would do it if you were in my position, which is just a terrible argument. So that's how it started. And then there was a motion to delay. Was it Blumenthal or Coons?
I think it was Blumenthal.
I think it was Blumenthal. And a bunch of the senators spoke kind of at length. It was actually one of the first times we saw them kind of interact with each other, right? Like, Cory Booker kept calling Senator Kennedy his friend. And like, we found out all these relations. Dianne Feinstein and Lindsey Graham are apparently very close. They hugged at the end of this today. And Cory Booker called Ted Cruz a closeted vegan, which was actually funny. It's not true, but it's funny. But Cory Booker really did have this really heartening speech about calling to this moment and showing restraint of power. And he said, this is one of those moments where there's that kind of grace that can stop this tumbling of this institution further toward what I think will be a real constitutional crisis. And it really did feel like somebody who was looking at the whole moment and calling us to that, more than it was just like, are you a racist? Who does your laundry? Will you overturn Roe? So I liked that.
I thought Cory Booker did a good job today. I think that's about as far as I got today. I think I like Kennedy started and I was just kind of like, all right. But yeah, I mean, he had a long speech where he basically was talking about, gosh, I he wasn't talking about Amy Coney Barrett. He was just talking about like our system of government and how it doesn't really feel like it's serving the people. And I think that was the gist of it. But he was a great speaker. I thought it was compelling, and it's definitely stuff we need to hear from someone in that room.
It was he made a comment. He was like, some of you might know I ran for president, but it reminded me that when Cory Booker was running for president, he kind of had this pitch to the heart of the nation or the soul of the nation, very much, and not to like save it, but to like remind us. He had this whole piece about, when he's from New Jersey, he was in Newark, and when he first was running for office, this woman like brought him down the street that was kind of dilapidated, and there were a lot of closed business fronts and all this, and she was like, what do you see? And he was like describing it, and she's like, I see my community, I see my town. And so he would do this whole riff on like, oh, say can you see, from the national anthem, and like, what is it that we see when we're looking at America? And it really reminded me of that's what his pitch was. It might have been a little just too early, maybe if he was running for president right now.
As he was talking, I was like, why is this compelling to me right now? Because I'd normally find it like, maybe, I don't think trite's the right word. I would normally just be like, I want to burn it down. What are you talking about, guy? But like, I thought it worked. You know what else was fantastic today? The testimony from, I didn't write down her name, Crystal. Yep. She's from West Virginia, right? She had an abortion. She talked about the judicial bypass. So she actually talked about some of the laws we do have in Minnesota that we are working on getting overturned. One thing she referred to as the judicial bypass process, where she couldn't trust any adult in her life. She acknowledged that many young people do confer with their parents when it comes to issues like, should I have an abortion? She just wasn't in that position, and she went in front of a judge. And she talked about how the judge, respected her, listened to her, but at the same time, she was someone with like a high GPA, could talk about her like involvement in school activities. And, she was worried about how that conversation might go for another kid who didn't have her that kind of a background. But I thought it was really compelling. So if you haven't seen it, you can see just the standalone on YouTube, or you can definitely see a clip of just her giving that speech, and it's like 100% worth watching, right?
It really was. She was the first person who told an abortion story during a Supreme Court nomination or confirmation hearing. And she was 16 when she had her abortion. She talked about, she's Black biracial. She has 3 children now. She talked about, her white stepfather actually sexually abused her, and she was in a relationship with somebody her own age, and it was the first relationship she felt safe and secure in, and then they had an accidental pregnancy. And she said, all these adults in my life had already failed me. These are not the people I was going to go to talk to about having an abortion. And she ended it with, I told the judge I was a good student and a leader in my school. I wanted to go to college to be a writer. Your Honor, I want to have a future. I choose to have an abortion. And she ended it with, you shouldn't have to have a high GPA or be a good, blah, 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 in order to access the care that you need. And it was very, very compelling. And I thank Crystal for telling her abortion story so publicly and in that setting where people have expressly advocated against her ability to do that. So it really was compelling, and people should watch it.
And I think that's like a great segue into like, okay, so the Supreme Court hears cases, right? And they hear cases about, among other things, abortion restrictions. But when a case goes through the court system, you have first the trial court, the lowest court, the district court, it's called different things in different contexts, but it's the trial court. And you bring your complaint, and that's the place where you basically tell your story. Assuming your case goes to trial, you're going to tell that story to like a judge or to jurors. You might give depositions. Your lawyer's going to frame what happened to you and put it in a complaint. It's really at that level, things are really about storytelling. I was a public defender for 10 years. For 10 years, I was helping my clients tell their story to the courts. And that's really what trial court level litigation can be about. But as the cases wind their way through the legal system, you get to the Court of Appeals, and you can have, in Minnesota, so different states, different places call their courts different things. In Minnesota, there's family court, juvenile court. We have a lot of cases start off in district court. So it could be Hennepin County, Ramsey County District Court, assuming your case is at the state level. There's like the District Court of Minnesota federal level. There's a lot. But a typical Minnesota state case may start, let's say, at Hennepin County District Court in downtown Minneapolis. Then you win or lose your issue and there's an appeal, and it goes to the Court of Appeals, which is a building in Ramsey County in St. Paul. All the statewide appeals are heard there. And then in Minnesota, the next level up is the Minnesota Supreme Court. And so when the case goes to the Court of Appeals, you can have two lawyers there talking to the judges without the clients even in the room. So like they may never see the person, hear their story. They're kind of deciding on legal issues, because that first court is the one where like the facts get established. And that could change. And there's some, this is a whole other interesting area, like what an appeals court can do with facts. But the appeals courts are really deciding like, okay, these are the facts the lower court found, like what's the proper application of law. So by the time that case reaches like Minnesota Supreme Court, like this is like so far removed from that original story a lot of the time. And so when you talk about the US Supreme Court, like it can be a real struggle to get like the real compelling, like, why is this important stuff in front of the judge, and not have everyone just treat this like an interesting academic legal issue. Originalism, which has been given far too much airtime. It really is a way of it's like another way of justifying taking the humanity out of cases. And so Crystal's story is super important. Think about like, watch that video and think about the effect it has and how it can change how you think about an issue. It can absolutely change how courts rule on issues, unless they've decided that they're going to like just disregard humanity.
Well, and that's, I mean, you think about there were a lot of conversations. You remember the Syrian boy on the beach and how that turned public opinion. It is very true that oftentimes it's one story that changes minds and not the existence of many. And so you can use a statistic like 1 in 4 people with uteruses will have abortions in their lifetime, but it's like this one person here was their obstacle. We're more likely to find that compelling. And so, you know, what you're saying is well taken, that by the time it gets to the Supreme Court, unless the case itself is about that person. So I think about Obergefell, or I think about some of the Title VII cases that we had earlier this year, you know, those were directly about people and their marriages. Otherwise, it's like these, you know, dry facts of how do we apply the law? Yeah.
So I would actually look at Obergefell. We did this before, like looking at Obergefell and looking at Bostock. So Obergefell is the gay marriage decision. It was a constitutional decision. Bostock was about an anti-discrimination law, statutory. Obergefell was written like Kennedy ended being like, you know, this is about like dignity and equality in the eyes of the law. And we would like, you know, this is all that they ask for, and we think they should get it. You know, it's moving, right? But if you look at the Bostock opinion, which is fantastic, it rules that sex discrimination in the anti-discrimination law does prohibit discrimination against gay and transgender people. But if you read the opinion, it's written by a textualist, which is
we have no choice.
Yes, like the law compels us, like it or not, this is what we have to do. And it just doesn't have that same oomph. And I like there's a whole movement out there trying to convince everyone that originalism is the only legitimate way to read Constitution. And that cannot be further from the truth, because originalists, like everyone else, suffer from confirmation bias. What they do is basically they take a question in front of them, it's a constitutional question, and they go back and say like, what did the framers, like what did they mean when they said things back at the time that they said them, like way back in the day? And if you actually read the opinions, it's like selective, like these aren't historians, they're lawyers, right? And they're just kind of selecting, like, we think this is what they mean. And so I think it's important to understand what that looks like in action. And you can really see it in like the Dred Scott case, the Plessy v. Ferguson case, right? We were talking about this earlier, Erin, right?
Yeah, we're gonna go into that. I think so. We're gonna post. I'm gonna do it right now in the comments. You know, Amy Coney Barrett on originalism, right, which is what she says that she is, says that for her, what that means. I interpret the Constitution as a law. I understand it to have the meaning that it had at the time the people ratified it. That meaning doesn't change over time, and it's not up to me to update it or infuse my policy views into it. And I just want to say that is in of itself a policy view, right? Like, I don't think that anything should be different now than it was in 1776 or 1895 or whatever. That is a policy position. It's just a very unpopular one, so that they've given it a really beautiful, like, fancy name. Like, it's just an originalist position.
And isn't it great when it just so happens to match up with your personal beliefs, right? It's just a coincidence. You know, it's not what made me pick this judicial philosophy in the first place as a way to like impose my policy views on people, but call it legitimate. Yeah, there's a lot to say.
It's just the kind of jurist I am. It's the kind of philosophy I hold. So we are going to talk a little bit about, because, you know, the testimonies today were fine, blah, blah, blah. But I do think that it is important to like dig into what can we glean from Amy Coney Barrett saying she's an originalist, and what has originalism looked like in the past in our country. Spoiler alert, not great. So I'm gonna intro the case, and then I'm gonna have you tell me about how originalism played in. Okay, so we're gonna start with Dred Scott. Dred Scott was an enslaved Black man in the United States who unsuccessfully sued for his freedom, and he claimed that he should be free because he had moved. The person who enslaved him had moved from the South to, I believe, Illinois or Wisconsin, where slavery was illegal. And so it went all the way to the Supreme Court, and they decided 7-2 against him, saying that neither he nor any other Black person could claim citizenship in the United States, and therefore he couldn't bring a lawsuit suing for his freedom in federal court under the diversity of citizenship rules. So Black people can't claim citizenship. 7-2. Just how did originalism factor into that decision?
So you heard a lot of, here are the things that you heard about originalism and Amy Coney Barrett's version of originalism, that courts aren't supposed to infuse their own policy, right? Policies for the legislators, we just like read the law. But we know, what you choose to like look back in time and glean from that is absolutely like a policy decision, right? Like, you could go back and support whatever you want to support. You can find something to support it if you're good enough, if you're a persuasive enough debater, you can probably just accomplish that. And that's all that's going on here. So there was nothing in the Constitution that said like Black people or slaves or former slaves or whatever it may be cannot sue in federal courts. Like, there was nothing in the Constitution that said that. So the court still decided, like, let's see, like, you know, citizens have access to the federal courts, but let's see, like, are Black people citizens? And so
what did the framers think?
And so they're like, they literally talk about like importing people, like their chattel, like importing people into this country, selling them as slaves. And I mean, this was true, right? Like, that is how people were treated. And then they say, it is not the province of the court to decide upon justice or injustice. Yeah, is that
what are you doing?
The policy or impolicy of these laws. In other words, like, we do not take policy positions. The decision of that question belongs to the political or lawmaking power, right? So like, let the legislators. Yeah, right. Where have we heard this? The duty of the court is to interpret the instrument they have framed with the best lights we can obtain on the subject, and to administer it as we find it according to its true intent and meaning when it was adopted. What does that sound like, Erin?
It sounds like Amy Coney Barrett.
Exactly.
It sounds like originalism.
And so basically what the Dred Scott court did was the majority, there was a dissent. They said it becomes necessary to determine who were citizens of the several states when the Constitution was adopted. So they go back and they're looking at, like, what did the framers mean when they said citizen? Could they possibly have meant Black people? And they say they're looking at they perfectly understood the meaning of the language they used and how it would be understood by others, talking about the framers, right? So like, this is exactly what you're hearing an originalism does, like what an originalist does, like what words, you know, what were the meanings of the words as the framers intended them back in the day. So then they noted, like, you know, there's all these states that don't allow interracial marriage, and there's all these, you know, when we look around at what all the racist things the states are doing, it's just not, it's clear that this is not what the framers meant, which
it wasn't. It was, I mean, so this is where therein lies the problem, right? And what it always comes to mind is like, what if in healthcare or like in medicine, doctors were always like, look, we know that you shouldn't still bleed people with leeches, that like, you know, babies born with jaundice need sun. But like back when they created medicine, we believe that. And so I know that it's harmful to people. I know that it's bad for them, but we're just gonna keep doing that because the first people who did medicine did that. Like this is what I hear. Like I know society has evolved. I know we have the wisdom of time and diversity and like evolutionary thinking, but what I'm really going to do is like dial back to an undetermined, like we, you know, who the framers are, by the way, is like this evolving group of people, right? But we're going to dial back to them, like this group of white men who were wealthy and, you know, had really specific views. What did they think and mean? And I just don't think that's where we should rest our judicial opinions on.
And you can do that and come to whatever conclusion, you know, like it's confirmation, but it's like, okay, what do I want to find? Because there was a dissent that's basically like, you know, at the time you're talking about, it's like some Black people were able to vote in some states, like, you know, the word like, you know, under a constitution, if you're born here, you're a citizen. Like you could look at the plain language of the text, like you can do, like you can come up with whatever outcome. And the dissenter said, this is more a matter of taste than law. And they were right? Like, and if you really look at the history of Dred Scott, like what the court was hoping to accomplish was to calm all of the like the United States was really split on this issue, and it was causing a lot of, they would describe, you know, the country split is causing turmoil. Let's put this to rest. And I think when a lot of people believe that when they came to the terrible decision they did, that it would calm things down. And of course it did not. But that, if that's not a policy, like, you know, yeah.
So let's look into another case where we might, well, originalism at work. So Plessy v. Ferguson. This was the U.S. Supreme Court decision that upheld the constitutionality of racial segregation in public facilities, so long as segregated facilities were equal in quality. So this is the separate but equal doctrine. And it legitimized the way that a lot of states were doing racial segregation, and they reestablished segregation. This was, you know, shortly after Reconstruction. So let's talk about how originalism shows up in Plessy v. Ferguson.
So the 14th Amendment was, you know, added later to kind of, it's like a post-war, trying to kind of address, I don't even know how to frame, like address slavery, address segregation.
I have the Constitution right in front of me, actually.
Oh no, but like explaining like the like insane injustice it's intended to like help fix it. It's like you can't really do it justice by even talking about it. But basically, do you want to say what it is from your pocket?
I struggle with Roman numerals, but all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Blah 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 blah. There's more, but yeah.
Or well, the big one for Plessy v. Ferguson, or deny to any person within their jurisdiction the equal protection of the laws. So there's been a lot of equal protection litigation. Plessy v. Ferguson, in that case, it was the question of, there were segregated rail cars, and the question of whether they could be racially segregated. And so the court just kind of found, basically what the court said was like, hey, there's laws forbidding like interracial marriage, and there's laws allowing segregated schools. Like, I don't think it could possibly be the case that when we made the 14th Amendment, we really meant to desegregate society. Like, this is about, so then they created this distinction, like this is about like political equality and not social equality. Like, it's
that like civic rights and individual rights.
This is, yeah, it's in the same vein of like, we're just going to make up a reason why this is different. And so they allowed segregation to stand, basically saying like, oh, they didn't intend this. Now what's annoying, I mean, what isn't annoying? is like now a lot of people who are originalists and when they get pushed on like, will you uphold rulings, like will you uphold precedent, usually they're asked that question like basically, are you going to become a judge and overturn Roe v. Wade? And what they say is you don't always want to uphold precedent, right? Like Dred Scott was terrible and Plessy v. Ferguson was terrible. So it's like these terrible opinions created by originalists, and they're like, look, we overturned those. You don't necessarily. It's maddening. Thankfully, like neither Dred Scott nor Plessy is the law of the land right now. Of course, we have directly kind of getting kind of, yeah, like so Brown v. Board of Ed.
Shelby v. Holder is precedent, right? So laws that were passed to address racial discrimination have been rolled back through the Supreme Court being like, hey, look, y'all don't have to like tell us anymore if you're going to pass laws targeting Black voters. Like that time is probably over. And it should also be noted too that like the Federalist Society, which is installing all of these judges, doesn't believe that the law should promote racial equality. It says that racial inclusion is just as bad as like racial exclusion is essentially their belief. And so, and that's where Amy Coney Barrett comes from, the Federalist Society. So I just want to throw that out there. Sorry.
And one kind of maddening thing in Brown v. Board of Ed, though, which is the case that basically said like, no, separate but equal is not equal. We cannot have segregated public schools, is basically, it's like one of the things the court said was like, at the time of Plessy v. Ferguson, we may not have really understood like the psychological effects of segregation on people, and we understand it now. And it's like, like you don't trust that the people going in front of you and saying this is discrimination, like you can't take them at their word. Like people are coming to you saying like this is harming us and this is how, like we're stigmatized, you know, it's not equal, like it's called separate but equal, but it's not. But even that aside, like it's stigmatizing. It affects our ability to learn, it affects our ability to thrive, like it has really serious effects on us. And the court's like, oh well now we get it because like psychology's updated. It's like you can't just listen to like the people who are telling you they're being harmed.
Yeah, I mean, one of the things that always gets me about Brown v. Board is that they did the black baby doll, white baby doll test to show that even like young Black children understood that they were viewed as lesser than. They would also choose the white baby doll. And it's interesting now because at the confirmation hearing yesterday, when Senator Harris was asking about, you know, Amy Coney Barrett's belief in science, is it settled science that you know, smoking causes cancer, and what was the other one she was talking about? Smoking causes cancer. I don't remember. But then it was like climate change. It was like, I don't know. And so it's like, if other people are choosing to ignore science and therefore are calling into question, like science doesn't cease to exist. You just have dumb people and then people who believe in science. So like, or people who choose to not believe in science and then science. It doesn't, like, if I wonder, I guess, is if all of a sudden someone went back into court and was like, actually, I have proof that separate but equal doesn't psychologically harm people, and that's just an opinion I have. Like, is that just as valid to her because it's a hot political debate? I don't know. I'm clearly just done with this whole thing. Did we talk enough about Brown v. Board?
Yeah, I mean, you know what we're kind of just saying at the end of the day is like, originalism gets talked about like it's like the only, you know, it's a separation of powers issue. Like the court is like overstepping its authority by doing anything but this brand of originalism. I just want to assure people who maybe don't have a legal background and are hearing this and are thinking like, yeah, like I guess judges should call balls and strikes, whatever. It is just all nonsense. Like it is, you can justify whatever outcome you want on a case with whatever your judicial philosophy is, and you can get there. And it's not a coincidence that a lot of people who choose to follow originalism, like it just so happens to support their policy views. Like that is not a coincidence. And if anyone made that clear, it was Justice Scalia, because Justice Scalia said time and again that judges are supposed to maintain like whatever the traditions are of society at the time, and they're not supposed to overstep that. And like, what does that mean, right? Like, so people in power are like white heterosexual cisgender men, right? Like what are the traditions of our society? Where do they come from? And how do you make room for more people to get into the legislature, to get into positions of power? Or even if people don't want that, just to like live, like how, if that's what you think the law does, then like what's the point? Like I don't think that that's legitimate. I don't think it's valid. I don't think it's the purpose of the law. And I think like any, you know, there's no reason to go along with this charade that there's one correct way to be a judge, and that correct way is to consider yourself someone who doesn't care about people. You're not like persuaded by anything other than like what did the framers think? Conveniently, they didn't care about like Black people or gay people or Jewish people or Muslim people or, you know,
or women or children or people with
yes,
disabilities or senior citizens or animals or the
right.
earth or, you know.
And I don't, yeah, like honestly, like the idea that they
Or Native
care so much
Americans,
about
sorry.
what?
Or indigenous people, continue.
Oh, yeah, absolutely. And the idea that they like were running around all day talking about abortion, you know, like this was the biggest problem facing the frame. Like the framers were like, you know.
But, I think one of the things that always comes up to me or always comes forward in my brain is that that imperfect though they were, right? They were human people that understood that they were human people. And I don't, if they wanted to make the Constitution very specific, they would have said like this value, equal protection under the law for these people. And if it wasn't meant to evolve, then it wouldn't be that broad. And so I think that the question for judges should always be, this value is good. The people who like put it forth were imperfect people who had very terrible views about things about humanity, right? So how can you take this good value and apply it to the society we have? Now, how can you reconstruct the society in which the people who made this Constitution in? And I go back to, I carry this pocket Constitution. I say carry, but like I'm not going anywhere. I used to carry it with me. Supreme Court Justice John Marshall, he had, it's Marbury v. It's very important. It's about, thank you. Very important case. And it's that a constitution intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. And so whatever brand of judicial philosophy that is, that's mine. I'm going to call it Marshallism.
No, I mean, it's a totally valid judicial philosophy that people use. Like there's nothing wrong with it. And that, like, if I wanted to, I could call it originalism, because I'm saying what the framers intended was for this Constitution to evolve over time. So like maybe I'm the original, like it's all just ridiculous.
Maybe I'm the originalist. I really like you are the originalist, Jeff.
Yeah, maybe you're doing policy nonsense and I'm actually the true, like I don't know, I don't care. But you know, this is what like 4 days of C-SPAN does to us. Like we're just kind of rambling, like, or not rambling, like we're just kind of like, I'm kind of just like annoyed and ranting. That's yeah.
Because here's the thing, Amy Coney Barrett is going to get confirmed, right? Unless some act of something, you know, it's a 53-47 partisan split. And I don't know, like maybe Joe Manchin votes for her. I don't know. But like if the senators don't continue to give themselves COVID and require themselves to be quarantined, then it's likely that Amy Coney Barrett will be confirmed to the Supreme Court. And nothing about what is like, everything that feels wrong is wrong, right? Like we don't have to pretend like she just came out of some sort of like judge oven that just created some sort of like impartial balls and strikes, like never had a thought or opinion. That's not true. Amy Coney Barrett signed a letter saying abortion should be illegal. She gave a number of speeches to hate groups and went through some sort of like legal training with the Alliance Defending Freedom and gave undisclosed speeches, by the way, at Notre Dame to anti-abortion groups, right? Like, so if the person who nominated her said, don't worry, Roe v. Wade will go away automatically because I'll nominate judges who will do it. And she has signed a letter saying abortion should be illegal. And let me show you all the ways in my career I have demonstrated that I think that is a fact. She's not going to wind up on the Supreme Court and be like, gosh, abortion, first I've ever heard of it. Let's dig in, right? So be scared and be upset and know that we are doing the work to make sure that, you know, that doesn't infect Minnesota, but like, it's okay to be upset. I clearly am. I was saying by the end of this glass of wine, we should be done, but
I think we're getting kicked off. I'm hearing it's 30 minutes, but we're gonna go off live now, but we need to stay on because I want to talk to you more about the judge oven.
The judge oven. Yeah. No, I'm not, I wasn't supposed to say anything about it. So, gosh, now it sounds terrible. I don't want to ever say, I'm going to say like the judge factory, right? I was thinking of like a cake coming out of an oven. I do think it's important to tell our like 6 viewers that the week after the election, So November 10th, there will be a case, oral arguments on the Affordable Care Act. Jess and I are going to tune in and we'll do a digest then. Isn't there another case coming up? There's multiple cases.
Well,
I mean,
Philadelphia, there's the case. There's a lot of important stuff and we are going to keep covering it. And we're going to be like way more, keep in mind, this is like day 4 of these hearings.
yeah.
We're losing our minds, but
Aaron brought wine. It's like,
yeah, but you can definitely join us for our SCOTUS chats. We're going to talk about the oral arguments that are as they happen, and you'll be able to find out without having to read of like 1,000 page transcript. You'll find out what happened and we'll explain it all. And if you want to find out more about our organization, genderjustice.us.
And if you're freaking out about reproductive rights, donate unrestrictmn.org. We're doing the work in Minnesota to protect and expand abortion rights. Thank you for joining us for 4 days straight. We're going to reconsider all of our life choices after we go off live stream. You're all wonderful. Thank you and good night.